Um, just a second.
Okay.
Let me have a
Just
look.
you can check that, and I'll ask anyway. I will ask all the participants to send in questions at any time that they want to.
Yeah.
We may address them in bunches or all together at the end of the webinar, but
Okay.
they should not hesitate to send us questions. Also because see, the topic of today's webinar is on gender neutrality, but I'm sure there will be some follow-on doubts arising from the actual 2013 Act and how to operationalize it. Okay, and you can't help but it is very natural for such for questions on the Act to arise. So in that case, I think our participants should feel free to send us those questions, and we will address them in. We will address them here. I will answer them. Okay, and where necessary, we will also ask Sibuni for her inputs.
Sure, sure. I think all the participants can listen to you. So I would request all of them to please feel free to post your questions. This is going to be the last session, and so ask as many as possible relevant questions which will be beneficial for your organization. So yeah.
All right. So let's start with how we can implement this act in a gender neutral way. First, I want to just outline what is the objective of this discussion. So the 2013 Act was introduced to prevent sexual harassment at the workplace. Okay, so now the question was that it was entirely women focused. So in this case, we are actually going to look at how we can implement this act in a way that it applies equally to men and women. So of course, the act does not apply to protect men against sexual harassment at work. But the point is that how can organizations create measures which protect men internally within the organizational framework. The second aspect we are also going to discuss is how a conducive workplace environment can be created so that apart from sexual harassment, other evils, other workplace evils such as discrimination at the workplace and harassment, these are also tackled. So harassment which is not sexual harassment, we're talking about that kind of harassment. And we will discuss UK and US laws also very briefly to understand what the meaning of this discrimination is, what's the meaning of harassment, and how employees in these countries are protected against these evils. We will not consider social security or other employment related benefits that are either governed under law or some of which may be created on a voluntary basis also by organizations. What is the point of discussing this? What is the objective? So there are certain benefits to having a gender neutral workplace. Before I go, so which arise from increased employee satisfaction. There is more collaboration at the workplace between people when they know that everyone is protected and there's an equal footing on which everyone is placed. Now the law was introduced with the objective of eliminating a certain workplace evil. Statistically, it is of course likely that women experience sexual harassment at workplace much more than men do. Okay. But there's a slight problem when you start implementing the act. There is a requirement in the act to educate employees on their rights at work. Okay, so a lot of companies, it is sometimes the message is unclear. Should you educate only the women employees or should you educate men and women together? And the problem becomes that when male employees realize that there is, that these rights are now suddenly going to all their women counterparts and colleagues, they tend to feel a little uncomfortable. Sometimes, they tend to view members of the opposite sex with suspicion. That especially when you are having an arm's length feeling, like there is a new colleague who comes to meet you. So at that time, there is a lot of suspicion that's happening. Now, some organizations also consider that okay, let's conduct sensitizations exclusively for women so that they know their rights. That again has this effect of polarizing the women employees and the male employees. What instead can be done is, so what is the objective? Even if you're sensitizing employees on women's rights against sexual harassment at the workplace, if see in any instance of sexual harassment, one party, the person who is, who is the defendant, who has been complained of as having indulged in sexual harassment, the other person also needs to be sensitized. He needs to also be explained what would constitute sexual harassment, so that knowingly or unknowingly he is aware of what sexual harassment is and what are the consequences of sexual harassment. In the absence of that, it will be very difficult to regulate employee conduct and to align it across a common ground where everyone, male and female employees, both of them know that, sexual harassment, that this is what constitutes sexual harassment and these are the consequences of it. I am including, any transgender employees who are working at the workplace. Many workplaces have them. So I am including them within the ambit of male and female. I will not be separately stating this term, just for the sake of convenience at the moment. Also, so let's look at the benefits that can be there in case there's a gender neutral workplace. And this is the reason, this is the moral, or this is sort of the organizational or a strategic reason why we can and should look at gender neutral workplaces. So of course, apart from increased employee satisfaction, there are lower chances of attrition. There can be better PR, lower reputational risks as well, because if you are protecting, so what happened in Tehelka essentially, in Tehelka there were clear-cut instances of the company trying to play the instance down, okay, play the instance of harassment down, because the allegation was against the founding editor. On the other hand, if you have an organization which has systems to tackle these problems, from a PR and reputational perspective, it will be much better, because it can clearly be said that, that we are looking into it and we have constituted a committee to look into it. So strategically, it might have benefits. And of course, there will be greater competitiveness. If there's a better workplace, then this is a sort of this is a non-financial incentive that employees will look forward to working at such a place, because it's a more friendly or it's a more equal environment. So now let's look at how the 2013 Act can be implemented in a gender neutral manner. If there are any questions, please feel free to send me. Mitali, please intimate me, okay, once there is a question, because the chat box does not automatically open. So, yeah, thanks. Moving on. So the 2013 Act, whenever it talks about the complainant, it is talking about the complainant in terms of the aggrieved woman, who is only defined to include woman. A man cannot complain under the Act. So if there is sexual harassment at work, any private organization or government organization is today only required to protect women. Okay. So a woman who is sexually harassed can complain, but a man who is sexually harassed at work cannot complain. There are some instances of men who have felt, that they have been sexually harassed at work, especially when they are especially when there is a senior-junior interaction involved. So these risks can arise. Now, how did organizations, what were the challenges or problems faced by organizations when this act was notified? So there were some companies and organizations which had already framed gender neutral anti-sexual harassment policies. They had done that on their own, either in compliance with their global standards. So if there is a large company, it is a multinational corporation with offices everywhere, and it's guided by their US or UK head office, then they would implement this in a gender neutral way across all their offices, including India. When this act came into picture, there is a sort of confusion as to, should we protect men? We always wanted to protect men because that's what we were doing. Now if we have to protect men, how do we go about it? There is a sort of vacuum. Okay, because to protect women, what they were doing was not enough. They had to create the systems that were mandated by the 2013 Act. So they had to create an internal complaints committee. They had to create a policy in a certain way. They had to start reporting and put notices in a certain way. Okay, so the entire issue became, how do we also protect men? the other organizations who became aware of this issue because the act came into picture and because of certain happenings, last year, which were reported by media, they also thought of introducing measures to prevent sexual harassment at work. But again, once they saw the act, they were like, we want to implement it in a holistic way. So how do we go about it? So this was the challenge. Moving on, so the question they faced was, they would have to do additional things in case, they would have to take additional steps in case they wanted to protect women. The question was, if they are going beyond the act, is that inconsistent with the act? No. The answer clearly was, every organization had its organizational policies, which through which it could implement internal measures to protect employees. Siboni, are you there?
Yes, Abhyuday.
Siboni, I just wanted to just add in here that in case you want to add in your inputs at a particular point, please feel free to stop me at that time and suggest and add in your comment. I will take everyone through this presentation, and I'll ask you specific questions also, but please feel free to interject at any time.
Okay. I'm not aware if this is a premature time to make this this comment. However, if I may, I want to point out very clearly for this audience that comprises of representatives from various different corporations, that very quickly, to give you an understanding of the landscape currently, just if I can take a couple of minutes of you there.
Yeah,
you put it out very well. Yeah. But I'll just take a couple of minutes so that there's an understanding. I have heard a lot of confusion from people to understand what this act means. This is not the appropriate forum between act leaders and myself when we're discussing how this act is to be implemented in each corporation, for us to actually discuss the merits of the act. So I'm not going to discuss the merits of it. However, very squarely, the Sexual Harassment of Women at Workplace Act 2013 clearly addresses the sexual harassment of women in a workplace. Therefore, the manner in which the act is set out and the provisions in the act very clearly mandate and require corporations to provide for optimum measures, which include committees, rules and formation of the committee, training of committees, the training of employees, towards understanding that the protected party is the woman, and therefore this is the mandate of the law and the regulatory requirement therein. Superimposed on this are the general trends that are international and global trends, and as corporations run alongside other corporations, which may be multinational corporations or Indian corporations, who are looking at the entire workplace in a more neutral manner in order to create codes of conduct, are actually welcome to and open to create these codes of conduct. Now, why would a company create a code of conduct? A company would create a code of conduct for a variety of reasons, including to be something that is an alignment with its own philosophy of business, its philosophy of growth, its philosophy of functioning, and in order to manage employee relations inter se and employer-employee relations. Now, all countries, and let's keep it to India, have the requirement of having, so we come from a historical perspective of manufacturing and industry seen as the original forms of organization. So we've had, of course, the historical series of the Industrial Standing Orders Act and so forth. I believe we'll go through that in the future.
Yeah.
However, the context here is that when you are creating these standing orders or code of conducts in a corporation, you're doing it in order to smoothen and facilitate the working of the corporation. When the state decides that it needs to engage or intervene to provide protection to a certain section of society, the state is responding to the requirement of the society. So currently, the state has responded to the requirements of society to enact the Protection of Women at the Workplace Harassment Act, and therefore we are all mandated to at the very least provide for women at the workplace, for curbing women, harassment of women at the workplace. That is the point here, at the very least. Anything above that is not illegal. It will, however, and this is the fundamental point, place more of an onus on the company in order to protect its employees and to provide a gender-neutral workplace. If that is the discussion that a company, and that is the tone and tenor that a company is willing to take. As we go further, I'll get into it, but fundamentally, nothing bars a company from providing for protection of harassment of both men and women. So you can have rules of conduct that discourage workplace sexual harassment from any party of either sex or orientation towards persons of either sex or orientation. My word of caution here, which is a feedback from various professionals that advise in this arena, both HR and legal professionals, as well as internal compliance managers and HR managers, which have to look ahead and decide at some level, are we taking a progressive line view of providing a gender-neutral workplace and therefore protecting everybody, all members of both sexes or otherwise, and members of different sexual orientations. So there may be a harassment that may be a harassment of a man by a man. Now, this in today's society is no longer an unheard of concept. Although we have not yet decriminalized this, the fact of the matter remains that society recognizes it, and when we are implementing laws and allowing for code of conduct to have better society and workplace, we do have to recognize it. As I clarify this point, my simple point is the mandate is only for the protection of women. However, the choice is for the protection of all members of the workforce. And it is a choice that companies take looking at the long-term view. The caution here is, yes, the requirements of the law are very stringent. So therefore, if you are taking a neutral view, the fact that the law has been enacted in such a manner that its requirements are extreme, and you may open yourself up for either inquiry or general administrative interference, there is a hesitance amongst the corporate community to open this out to gender neutrality. This is a discussion that is going forth. CII has taken it forth, Mitali, if I'm correct. I know FICCI has taken it forth, and it has also gone to the CWC, the Center for Women and Children, to have this discussion that the manner of enactment of the Act should not discourage companies from, in fact, pushing this code of conduct, and the desire to have a neutral workplace should not discourage a corporation from, in fact, opening this out despite the fact that there are onerous provisions in it. I hope that makes it a little clear at this point. Sorry, Abhyudaya, to continue. A little bit was repetition, but it was just the clarity of what is required by the law.
Okay. Thank you, Shivani. I guess Abhyudaya, I can see due to some technical difficulty, he is logged off. He'll be logging another just 2 minutes.
I will just take it forward from here.
Yeah,
if you're okay with that. I don't have control of your presentation. However, if you could move on to the next, I'll carry on.
I'll give you the presentation, right? Just give me a second.
That's okay. Right now, flip to the next page, and I'll just carry on discussing what's on my, as an expert, what I feel about this. So going forward, now, what kind of environment, just expanding on what we're talking about, what kind of environment that is a corporation's decision, personally. Sorry about this, Mitali. I'm hesitating because you've taken me as a presenter. Don't give me presentation rights because the presentation's gone from my screen. Let's continue. It'll break the chain of thought for our audience.
That's okay. That's okay. That's perfectly fine.
I'll keep talking. Don't worry about it. I don't need the presentation.
Okay.
Thank you.
Okay.
Okay, just take it back to the rights and continue. Right.
I'll
so
do
coming
that.
back to the discussion on what kind of options do you have as representative of companies to in fact advise the company or take this forward. Now, I'm not going to discuss the merits too much of which of these will apply for you. However, you can take one of the two. You can take the model and have one set of rules that applies to the entire corporation. So what you have is the prevention of sexual harassment at the workplace rules. Please note, there is no word man, there is no word woman as I recite this. In those rules, the rules then provide for the requirements that are as highlighted by the law and as provided by the law, fundamentally having a committee, training that committee, the constitution of such committee, the rules by which this committee shall conduct itself, then going forward, the education and the training of employees, the rules that shall apply to how employees shall conduct themselves in general in a corporation, and in what manner they may approach such committee under the rules of confidentiality, lack of bias, fairness, and openness and transparency. These being the fundamental rules. Now, when you apply them neutrally for both men and women, what that means today is you look at the act, and if you're hiring an expert or an external agency to assist you and support you in ensuring that you are entirely in conformity with the act, what this means is you will be providing the same protection that is required of the law to both men and women, and thereby you will make arrangements in order to address issues in the same manner, whether for both men and women being victims. And while I say men and women, without any reference to the law and the requirement, men, women, and any other manner of description that somebody may wish to describe themselves, and that I don't have a point of view on. So harassment of both men and women, and harassment by man, women, or either. Man, women, and or either. Now, this is the generic outlook to say this is one manner in which you may enact this act in a gender-neutral manner, therefore addressing all situations in which sexual harassment causes disruption in the workplace, causes a long-standing or a short incident which disrupts the workplace, spoils the workplace environment, renders the workplace less productive, and of course leads to longer-term effects of lack of confidence, discrimination against women, which then moves on to discrimination on the lines of sex, race, caste, orientation. If you allow discrimination, you will allow it in many forms. That is the trend. That is what you start noticing that people move towards. So that is one manner in which you may implement this. The second manner is you can create separate mechanisms. Now, although this is logistically and administratively very challenging, there is an understanding amongst legal advisors that cautions corporations that have the intention, the appropriate intention, to in fact protect all members of society. However, because the act is extremely onerous, it has some requirements that are sometimes not clear, and also reporting and other police state related environments requirements that may burden a corporation. Therefore, some corporations are choosing to address issues and allow redressal of such issues in a neutral manner to all their employees, managers, contractors, so that they are promoting a finer workspace, however creating two totally different administrative models. We're always happy to advise you on how these may be created if that is the concern that a corporation is having. However, these are the two models that may be available.
Yeah, Shibun, my connection is back. Yeah, I'm back.
Excellent.
I'm back.
Abhyuday, I've already covered what kind of committees we may have. what gender
Okay.
neutrality would imply. And
Okay.
you may take over, I think, the next slide. So we're already done with the slide that's on board and
There are two
discussing
models
it.
that are possible.
Yes, we've already discussed that. Yes.
All right, all right.
And I've already made some comments on what really exists and what corporations are looking at and where corporations' challenges lie in this manner.
Okay, okay.
Yeah,
So in case any of the participants want a detailed clause or a notice or a gender neutral policy, they can just send us an email at this email ID. I will proceed to the next slide. So now we'll move to the next part where we want to explore the other Indian laws which relate to treatment of employees at the workplace. So I will, and whether they apply to private entities or not. We will just quickly go through that before we go to the law in UK and US and understand what workplace harassment or discrimination is. So Indian laws are largely, this is a quick summary slide, that Indian laws are largely focused on prohibition on discrimination in public employment on certain grounds. They are not applicable or enforceable against the private sector except on certain grounds only, which we will just discuss in a moment. So we start with what constitutional provisions are. There are a couple of articles in the Indian Constitution. Article 14, which mentions equality on 5 grounds. So there can be no discrimination in a government employment. You know, when you're employed with a government department or a PSU or entities which are where a central government or where the state governments are controlling the entities. So the other article under the Constitution is Article 21, which includes the right to livelihood and the right to live with dignity. So workplace harassment and discrimination clearly interfere with the right to earn a livelihood, because it discourages the employee from working at such workplaces. And it, of course, harassment would directly interfere with dignity of any employee at work. However, we do not have laws or enforcement mechanisms for protecting directly the employees working in the private sector against workplace harassment. I will quickly say which are the acts that are applicable in the public sector. We just discussed the constitutional provisions. There is an act which protects persons with disabilities. So 7 kinds of disabilities have been mentioned in the Persons with Disabilities, but it is written in the act that it applies to the public sector entities. The wording is in government establishments. The next part now, Equal Remuneration Act and Maternity Benefit Act are applicable to the private sector in India. What are they talking about? The Equal Remuneration Act is stating that certain employment terms, firstly the remuneration, training, promotion and transfer. On these 4 terms, there should be no unequal treatment between men and women. Okay. Is this gender neutral? Interestingly, it is gender neutral with respect to the remuneration, but it says that women, on the other aspects, training, promotion and transfer, it says that women will not be discriminated vis-a-vis men. Okay. Ironically, it has just been worded that way. So it may not be enforced in a gender neutral way by courts. Only the remuneration aspect is clearly stating that men and women will be paid equally. So there it is gender neutral. Now the Maternity Benefit Act, of course, is protecting women in the event of maternity from being terminated from employment and allows for certain social security benefits. So these are the main statutes that are applicable to the private sector, which with respect to the employment terms. The next aspect is the Standing Orders Act. This applies to industrial establishments. Typically, it is factories and places where a large number of employees are working. It will not apply to smaller organizations. There were questions of whether whether this applied to the industry in Karnataka, to the outsourcing industry, and Karnataka had a state government exemption which stated that the outsourcing sector will not have to comply with the Standing Orders Act. Now, however, there are various other establishments to which this will be applicable. The Standing Orders Act requires employers to have standardized employment terms and conditions for workers working in these industrial establishments, and to get them certified by an officer of the government. So now these model terms should have certain grounds. Certain model terms must be included. So the employers are free to specify the specific term, but the heading or the content is broadly specified. It is not specified to the T. So employers have certain freedom with respect to customization. So the terms which there are three heads called termination of employment, dismissal for misconduct, and acts which constitute misconduct. These three acts, these are pointed on the screen right now. So these are the three heads which must be there in any standing order. However, what should be the detailed content has not been included. So under the 2013 Act, of course, it has been written that sexual harassment at work, sexual harassment of a woman at work should be treated as misconduct, that an employer is bound to incorporate that in their employment policies or their service rules or standing orders. However, if they want to go a step ahead, they are free to include harassment and discrimination as well. What is the meaning of these terms? They can have technical meanings. We will discuss them in a while. So, Siponi, I would like to take your inputs here on what we have just discussed, in case you would like to provide anything.
Okay. Going further from the point of, I think your question was, is the law gender neutral? Our audience here, I suppose, would not really, as we discussed earlier, be wanting us to discuss the merits of the law. So what my opinions or other working professionals' opinions of the law are entirely outside the purview of this. However, coming back to the fact that there is a mandate for compliance with the law. Fundamentally, when we have compliance with the law, we have to look squarely at the Act and comply with the Act. Now, as we look to expand ourselves, and as we're trying to discuss today, the neutrality of applying the Act, we cannot make the Act any more neutral. We can only make our conduct and what we require of our corporations neutral. Why would that be beneficial to us? Because going forward, what kind of workplaces do we wish to have, and what other inequities in a workplace that can lead to disruption of a workplace, that can lead to inequalities, and also, as Abhyuday outlined, can be actually argued under various other provisions of law if that inequality gives rise to either incidents or perpetuates an environment that does not allow for the conducive working of that industry. So without making it extremely onerous on ourselves as industry, when I say ourselves, I'm talking about the audience in general here, which is going to today consider, amongst you there'll be lawyers, HR professionals, operations leaders, thinking, what am I really required to do, and how am I how am I within the compliance of this law? Companies have gone, well, international companies in any event are required to comply with laws from the countries in which their head offices are and in which they were originally incorporated. So US companies, we'll discuss US law, will actually cover discrimination, disabilities, harassment, right to earn a livelihood. When we put all these together, what is the sum total of what you get? The fact that you're creating a workplace environment that does not encourage, let's make that more prolific, that discourages any form of discrimination at the workplace. We do not need to put this entire basket under the vehicle which in fact shall be implementing the Prevention of Harassment of Women at Workplace Act 2013. That's a requirement. So when we are actually implementing that, we can put into place rules of conduct to squarely address sexual harassment. The general discussion here is when you are squarely addressing sexual harassment and you are in fact taking that opportunity and that effort to inculcate this and train members of your amongst the employees, you want to have some idea of what are the other discriminations that lead to issues and that have underlying compliance in laws like the Constitution. So having a code of conduct which in fact encourages diversity, discourages any discrimination on identity, gender, class, caste, origin, orientation, is a workplace requirement that would be a good thing and would not in any way render the company either conducting or engaging in an illegal act, but in fact a company would be seen as much more progressive. And that these issues have to be addressed, can be addressed in a multiple of manners, and you do not need to mix the issue with the sexual harassment. So you can actually keep the sexual harassment committee entirely separate, address the issues that are required to be addressed under sexual harassment, and in fact have code of conduct which discourages any other forms of discrimination, discrimination of persons with disabilities, so discrimination of persons that are currently women that are expecting. Now all these have been covered under various acts. We can actually look at the various acts and create a code of conduct that squarely addresses all of them. And as by way of suggestion, companies have ombudspersons that address industry issues. Companies are also open to have an ombudsperson or an HR cell or an operational cell that addresses fundamental issues which does not allow these. Now, you're not required under the law, but you're only creating a better conducive environment to run the company and looking one step ahead of the law. For 9 years, between Vishaka and the enactment of the law, many companies set up sexual harassment committees. Many companies didn't. They saw that this may be a hindrance to their business. In fact, not having a committee is a hindrance to your business. So my viewpoint is, in fact, not having a gender-neutral environment in which you can actually create different mechanisms to address it, and not having a non-discriminatory environment is not looking ahead in order to create a good workplace. That's my only addition. Thanks, Abhyudaya.
All right, so let's quickly take a look at how US and UK laws are designed, so we can take maybe some pointers from them for organizations which want to implement laws in a gender-neutral way and which want to go a step ahead and protect their employees from a broader category of workplace harassment-related issues. So US and UK both have gender-neutral laws. We will not be considering the enforcement mechanisms under those laws in detail because we don't have such laws in India, and organizations cannot take those steps because only under a law they are authorized, right, such steps. So organizations need to enforce these at an internal level. So the steps that will be taken for enforcement will be different. So let's just take a quick look at the laws. So the United Kingdom has a recent Equality Act. So they've had a string of legislations earlier, a string of statutes, and when there is an amendment or when there's a major change, you will have the act will be reenacted. So although the Equality Act was passed in 2010, they had a lot of legislation earlier. They had extensive legislation which was covering equality at work, which was covering equal treatment at work. Now, quickly, the features of the act: it is gender neutral and it provides 9 grounds which can trigger a discrimination or a harassment claim. So some of the grounds are very detailed. For example, sexual orientation, civil partnership or marriage, race, religion, sex. We have these in India. Disabilities there. Gender reassignment again is progressive. age is progressive also. You know, you always have people saying that unless a lawyer has gray hair, he's not worthy enough to be an experienced lawyer. Anyway, this was from my personal experience, but what let's look at what the meaning of discrimination is, because that is the critical point. You know, and the Act has defined that in a lot of detail. So treating an discrimination could be direct or indirect. It is direct discrimination if you have treated an employee less favorably. It is indirect discrimination if a work-related criterion, provision, or practice is applied in a discriminatory manner, which means you apply it irregularly, inconsistently, or in a way which distinguishes one person from another, all other factors relating to work being equal. Right? But the grounds are only 9. So if you are discriminating somebody on some other kind of characteristic, this will not be triggered, because discrimination is only triggered on the basis of the 9 grounds that are presented on the screen. Okay, so even there this claim is limited, but these 9 grounds are pretty, you know, they are pretty vast. So really, otherwise, so there could be situations where there is discrimination on other aspects. You know, somebody could say that, oh, this person is from the Ivy League. Okay, I'm not sure how we would be able to cover that here. If somebody has, let's say, if somebody is Harvard educated, and you know there is an organization discriminating that way, could you actually have a claim under this Act? I'm not sure, probably not. But on these 9 grounds, they would. Now compare this with Indian law. In Indian law, we were talking about recruitment, remuneration, training, promotion. Okay, there were 4 grounds we had mentioned. Discrimination, so equal treatment was required only on those 4 grounds. That only with respect to women. Here, we are going beyond just what the terms of employment are, because the scope, what you do in your employment is much more than what is just written in your contract. There are tons of other things that, you know, there are tons of other practices, organizational culture, ethos that is flowing into your scope of employment every day. All these cannot be written down in a document. Now the Indian law is only covering recruitment, training, promotion, these kind of things, which are very, very self-evident when they are happening. But this is going beyond when you're looking at indirect discrimination. It's saying any work-related practice or criterion. So you are going beyond just what the terms of your contract is saying. Because in India, in any case, you will have, in many cases, you know, we have very open-ended employment contracts which do not say everything in writing. They are not exhaustive. And practically also it is very difficult to have an employment contract which is just about everything that you will have to do or every practice of the organization. So to be able to be vast enough, it has to cover organizational decisions, practices, strategies. Now moving on to the definition of harassment. So how is discrimination and harassment, how are these different? In many countries, a lot of times discrimination and harassment get interlinked. So harassment could be even understood as a way that, you know, okay, there is discrimination happening, and you know, you don't have a clear definition a lot of times, but we're looking at the UK Act because this has a very, very clear distinction here. And the UK Act is saying that unwanted conduct related to any of those above 9 factors. So which has the effect of violating a person's dignity or creating an adverse environment, which could be intimidating, hostile, degrading, humiliating, or offensive. So here we're not really thinking about has this person been differently treated from someone else while applying a work measure. You know, has he been given an important project while the other guy wasn't? Has he been given a special kind of incentive? We are not talking about any of those measures. We are just talking about any unwanted conduct that is degrading or humiliating an employee, but which again emanates from those 9 characteristics only. That unfortunately is a limitation even in the UK Act. So, and I'll broadly take you through the consequences of violation, that are specified in UK. So one is very, very basic, that any direct terms in your employment contract which are discriminatory would be violative of the act, so they cannot be enforced. The second thing is that there is an employment tribunal created in UK which can directly, order the employer to take corrective action or pay compensation to the employee who has been discriminated or harassed. The next, so as I was saying, UK had legislations earlier as well. So one of them was the Protection from Harassment Act, which was not workplace focused. Even the Equality Act is very exhaustive. It's not just workplace focused, but it has a specific chapter dedicated only to workplaces, which is what makes it so powerful and so effective. The Protection from Harassment Act, on the other hand, this was a general and very short legislation, simply stated that it was prohibiting harassment in general, whether it is from law enforcement agencies, police, or at workplace. It was neutral on that. There was nothing special for workplaces. It entitled anyone who is harassed to a criminal remedy. You could go to the police basically, and the punishment was a 6 months imprisonment and fine, and compensation. And compensation was granted on the grounds of anxiety and financial losses. Any anxiety and financial loss that was suffered by the victim. So let's move on to the US law. US has different state and central laws. We will just look at a central law here. So they have a Civil Rights Act which extends to private entities. Again, this is gender neutral. It prohibits discrimination on 5 grounds. Okay, with respect to hiring, terms of employment, employment opportunities, and training programs. So again, this is not as wide as the UK Act which we saw, which talked about indirect discrimination, which talked about applying any employment measure differently with employees. But this is talking only about hiring, terms and conditions, employment opportunities, and training programs. Now there is an interesting observation from US laws that we have. So sexual harassment at work is emanating there from this provision which prohibits discrimination on the basis of sex. From there, courts have read it in to include sexual harassment at work, and subsequently there are lots of policy guidelines that are available on the internet which will explain what sexual harassment at work is. An independent regulator called the Equal Opportunities Employment Commission was created, which has issued these policy guidelines. But what is interesting here is that apart from sexual harassment, they are covering other kinds of discrimination on the basis of sex also, which is sex-based but not sexual in nature. Okay, so I'll give an example here. So if you have an employer or a senior saying that, who is screaming at this junior stating that you men are not ambitious, I need to have more women in my team. Okay, or if somebody is just stating, this is just by way of example, that okay, men are not intelligent or women are not intelligent. This is not an intelligence or ambition is not an inherent characteristic of any sex. But if somebody is discriminating or harassing an employee on the basis of such characteristics, this becomes sex-based discrimination in the US. So the regulators have framed detailed guidelines to explain when this kind of statement amounts to harassment, when it is serious enough, so that there are no frivolous, to ensure that there are no frivolous or malicious claims or trivial claims that are brought before them. And they have separate laws for covering disability and age-related discrimination. So what were we stated that an Equal Employment Opportunities Commission has been created. They have the powers to explore conciliation. Conciliation is also is an available remedy under the 2013 Act, or take civil action against the employer. Again, this talks about going to court and enforcing, and claiming compensation and similar remedies. The interesting thing about India is that the 2013 Act is requiring employers to create ICCs and have internal mechanisms, and it has a framework for addressing this problem. The advantage is that if we implement the Act, okay, the risk of employee litigation where employees are claiming compensation goes down drastically, which may not be there in UK and US because their employment litigation is extremely frequent. It is extremely voluminous. Courts have awarded very high amounts to employees. Recently there was an award by a court in Australia against an employee of, against one of the senior management of Oracle, and it was of a huge amount. So that practice is also arising because there is a possibility that the EEOC or the Attorney General, for example, in US law, these authorities have the power to sue or prosecute employers in court. In India, we've created these mechanisms where they can be internally settled, which is an advantage, I would say, for businesses. Siboni, if you have any comments, I would love to have your inputs on this.
Okay, at the risk of being a bit generic, we've already discussed where companies may take progressive measures. I mean, I've pretty much spent most of my time advocating that in order to recognize the fact that that is the trend which the law happens to take. You know, 10 years ago, I'm just going to make a parallel discussion since everybody here is from a corporate background. You would have wanted the government to have a progressive outlook to general governance and compliance, and today you have the New Companies Act, which has great amounts of emphasis and mandate required of corporations, of companies basically, under the New Companies Act, which relates to governance and compliance. Very similar in that tenor. What is the idea of looking at UK and US laws? It's not as if we actually just look towards the West and in fact pick up provisions and use them. We have societal needs, we have requirements. Really reading from what the trend of, what the global trend in corporation and corporate etiquette and corporate code of conduct is, it's at some level you know, almost intuitive. It's an intuitive reaction. So while we are sitting here discussing the implementation of the Sexual Harassment Act, today after doing 6 seminars on this, making many companies familiar on it, we are wrapping with a discussion around neutrality, discussing other countries, simply because, to give you an idea, intuitively, I would not be surprised to see an act that actually encompasses good governance, that encompasses all these requirements. Now, do we need to wait for it? No, we don't need to wait for it. As corporations, we can take the onus without, in fact, being circumspect or even so far as fearful of what would be the administrative challenges. I'm somebody who's worked in-house as a general counsel, so admittedly I would share with you that one of the concerns that we do have as general counsel sometimes is overreaching our good intention, since the engagement with the administration is not necessarily, in the past, has not necessarily always been productive. We have a very, unfortunately, we have had for 60 years a very slow-moving justice system. So companies which are there for the business of business are slow to actually engage themselves in the criminal justice system unless they were in fact visited upon by it, which is the reason we're here. Now there is a law and therefore we must implement it. Keeping all this in mind, it is still very much to the benefit of the company to take cue from the fact that there is a law today that is protecting women at the workplace. How this law came into being, a lot of you will be, I'm sure, have discussed this in your corporations, seen it on the social media, seen it in the mainstream media, discussed it amongst yourselves. The history of the law is relevant only so that we have a better understanding of where we may likely actually proceed toward. So therefore, having a corporation that finds that its central code of conduct looks towards where a corporation will actually find its areas of challenge or potential areas of disruption would be a good idea to in fact have codes of conduct that already squarely address that. So there are some very forward-thinking companies that have actually had this act in place, had these committees in place, as well as internal rules, not very elaborate necessarily. They need to be elaborated according to the law, but addressing that in fact, for whatever reason, after urbanization and the joining of women in the workplace, there was a certain amount of discrimination and a certain time lag till the fitment of this came into industry, that you wanted to protect women. So as of 14, 15 years ago, many corporations have had very simple internal policies saying if there is harassment of women, there shall be an ombudsperson, you shall approach that person, we will keep it confidential, we'll address the issue. In a very like manner, industry, media houses, I have no idea if there are any media houses attending this. However, industry follows what the trend is and therefore thereby puts into place governance requirements that actually address its own issues. So most media houses today have an ombudsperson in-house which looks at issues that are engaging with industry, employees, contractors, spokespersons, because there is such a large flux of persons in it. IT industries had very odd, as compared to earlier times, work timings as well as workspace allocations. There was a great amount of interaction. So therefore, different aspects of the industry had to be looked at to in fact address these issues. That is why looking at the Sexual Harassment Act, what is an instinctive, intuitive reaction of a corporation recognizing its own workplace? I have worked and advised industry, smaller industry, which is very small in semi-urban areas. I wouldn't say rural because it's still conducting large industries. We have many, many areas such as those, and many of you will be running probably manufacturing outfits or service centers, distribution centers, where the responsibility of the persons engaging in those businesses comes back squarely in a human relations aspect back to the corporation. So looking one step ahead and in fact being able to have codes of conduct that encourage more neutrality, less discrimination, good workplaces, looking at the trends as well as the specific requirements of your own industry would allow us to in fact be able to enact these and implement the requirements of regulation much more easily. Now, although this is a very progressive discussion, it squarely ties back into the requirements of the current Act. When you are actually implementing the current Act, you do not wish to only have an employee training that actually just squarely discusses that you will not harass a woman. I think every employee wants to know that you will not harass each other on the leverage and the basis of what your workplace positioning and status is. You're in fact in a workplace in order to maximize potential, maximize productivity, and minimize wastage, and of course various other specific nuances of that industry that allow a corporate structure, an organization, a school, an institution, a hospital, and so on and so forth to function in the most effective manner. To tie this in, of course, the mandate still remains at the base level. It is a requirement, a necessity, and today a legal requirement, a legal mandate, which therefore renders it illegal if we are not following all the steps that make a workplace more conducive to diversity, more conducive to equality, and of course squarely as per the Act discourages, restricts, and controls sexual harassment of women at the workplace. So extending your mandate is entirely the prerogative of a company. We have extensively discussed. Please feel free to ask questions. I myself, as a practitioner and as a lawyer and as an advisor, when we started out 15 years ago looking at Vishaka, had many questions on how we would actually protect people without it being misused. And something that we haven't discussed here is there is a perception and some, I would admittedly say, there would have been some experience as well, that there is the likelihood of misuse of provisions that are in fact provided for protections of certain sections of society. That is not a new phenomenon in society or in public life. When there is protection of any members of society, as there is in various legislation and law, not just for sexual harassment, there is the risk. I would not go so far as the trend, because that is not entirely the case, but there is the risk, and there is also the prevalence of misuse of law. Now, if we wish to control the misuse of this law, then one of the best manners in which you can actually control the misuse of this law is, in fact, make provisions, find trainings, engage with the employer entire workforce in such a manner to encourage the neutrality, therefore discouraging misuse by any sections of the society. Better understanding and better education and better training can only lead to better implementation. So all these fears, when this act was enacted exactly a year ago and then the rules came into being in December, there was a lot of feedback from the media in the corporate sector, and the two realms were, one end was let's just enact it whichever way possible with very minimal interest in squarely understanding that this could address a variety of issues, and the other feedback and reaction was, oh my God, I don't want to hire any women because we have to protect them and therefore they can be misused. Somewhere between these two extremes, squarely at the center, lies good and correct implementation of this law. Good and correct implementation of this law squarely remains to be in good governance, which basically is a fine policy, a clear dissemination of the policy, a committee that is fair and available, rules that are created for the committee, and consistent understanding of employees as they join and exit the company or are trained from time to time as they take over different roles, of the understanding of the codes of conduct, one of which will be lack of discrimination, no sexual harassment, no workplace harassment. And if you're keeping it to the bare minimum, no workplace harassment of women at the workplace. No sexual harassment of women at the workplace. That is really my view at this point. Thanks, Abhyudaya. Is there anything else I can squarely address for you?
Thanks, Shibani. That was very, very useful at this juncture. Thanks a lot for that. We will. I'll just wrap up the discussion we were having. So it's actually on screen. So laws in US and UK, we've seen how they are gender neutral, but organizations can incorporate some of the aspects and and create gender neutral frameworks for strategic reasons. So here there's a model clause which we had suggested here, but this is taking certain grounds from the UK law, the 9 grounds. Organizations may want to check and add or subtract the grounds that work for them. For example, I don't know how relevant gender reassignment might be in India at the moment, but so they could add other grounds. So we've just put in a model clause. The meaning of harassment and discrimination has also been defined. It has been given a relatively, simple meaning which can be read and understood. If you actually refer to the UK statute, it gets a little more technical. Anyway, but this is all subject to the riders and inputs that Shibani has suggested right now from her experience, which is extremely valuable. What could be the enforcement mechanism when such clauses are incorporated in policies? With respect to, so there could be either the internal complaints committee itself or an ethics committee, an HR person or an ombudsman. There could be varying mechanisms that organizations could choose, as long as for sexual harassment of women at work, they are complying strictly with the 2013 Act. That is, they must have an internal complaints committee constituted as per the Act. For the other aspects, organizations can choose other mechanisms. Where standing orders are applicable, they can incorporate these terms in the standing orders as well. That wraps up the discussion on gender neutral enforcement. and I would thank Siboni for all her inputs on that. We will quickly move to the demo and introduction to a cloud-based compliance and training toolkit that we have created, which simplifies compliance with the law and training aspects. So I'll quickly explain, the problems that were being faced by industry. The moment, and which is what goes into, creation of this toolkit. This toolkit has been created by IP leaders, and it is technology. It's based. A lot of technology has gone into that. It is technology focused, and it is not, how conventional trainings used to be conducted. I am just explaining what challenges are being faced by industry to better explain the reasons for the reasons and vision behind why it was created. So when the act came into picture, it was to apply to all organizations which have 10 or more employees working. Okay, and so which meant that the organizations had to sensitize and train their employees on their rights at their workplace. They had to create committees, and the committees had to be trained on how to hear sexual harassment complaints and decide, how to take evidence, how to take a decision, what decisions they can take. So all these were quite challenging tasks. And if you have to really train committees and employees across the organization, it can become a huge task. Finding experts, there were logistical hassles, and there were a lot of hassles around who is the expert we can find, because even the experts who were available, sometimes it was very difficult for them to take comprehensive training sessions without, let's say, any intervention of technology, to be physically present at every manufacturing outlet, every factory, every retail outlet. All these becomes quite difficult. So finding experts was one problem. The experts who were available until then were, a lot of them were corporate trainers who would be good at trainings, but may have to develop further skill sets to give a legal training, because employee sensitization post the act became a little more technical. And of course, training of the ICC is a very, very technical task itself, because that is completely completely technical, and a lot of elements of law also get involved. So finding experts for that was a problem. Also reaching out to all the employees at the same time was a problem. Many employees have, they may be working in shifts, or they may be taken out on important projects, they may be traveling. So having everyone congregate at a place for a session was very difficult. So repeated sessions had to be conducted, and it sort of became unmanageable. And then of course the issue of when an employee has learned something, how does he retain it? How does he have something accessible to him which he can carry everywhere? Give employee booklets, a lot of times people, they put them away, stash it in a drawer, or they might lose them. So how do we ensure that this training is effective, continuous, and all legal updates are brought in? So training turned out to be very expensive also, and it was difficult to demonstrate. Now imagine after the law has come, imagine if there's an investigation and you are required to demonstrate. How do you demonstrate that you have trained employees? You could say you've conducted X amount of workshops, or you could go a step ahead and you could say that we have not only conducted workshops, but we have administered assessment and certification also. Like we have administered third-party assessment tests, where employees have actually taken the tests and been certified if they have passed the tests, right? So this could be a possible way to demonstrate effective compliance. So we created a toolkit which is basically accessible on the internet and on the mobile. I'm going to show the internet version very briefly, which has been made after consulting experts who are top lawyers or who work with HR in organizations, and this has had the support of industry bodies like CII, and we are very thankful to CII, which has been extending support to the toolkit. We have displayed the experts who have helped us and who we have consulted while we created this toolkit. They are on screen. As a summary, so I will just say there are three aspects on which the toolkit is helping. One is capacity building for complaints committees. That's the left box. Second is the sensitization aspect. So capacity building has implementation guides, decision formats, case studies, these are, and then there are downloadable formats of decisions which can be customized depending on a case. But standard aspects are already included in the format so that, and you don't have to reinvent the wheel and learn all of it from scratch. You can it's like a plug and play solution. The next aspect is sensitization of all the employees. So this is video-based training and text materials, quizzes, all these are included within the sensitization aspect. There are also some practice questions for employees to take. Also at the end, they have the option to opt for, organizations have the option to take, to administer a test based on the sensitization, which will result in the generation of a certificate for employees. The next aspect is on the compliance. So apart from training the ICC and sensitizing, there are certain compliance aspects which are important either from a legal perspective, or there are strategic requirements. For example, how do you articulate an effective organizational stance against sexual harassment? Because if assume an organization has multiple offices, you don't want the 10 offices to behave differently. You want some element of continuity, some kind of coherence on the kind of decisions that are being taken in the organization, right? So how is a coherent stance against sexual harassment to be articulated in an organization? Aspects such as that, and compliance formats, annual report formats, notices, flow charts, checklists for taking specific actions. So what could be a checklist for drafting a anti-sexual harassment policy? So these kind of aspects are included. I am providing some screenshots here, which you can view. Android screenshots are also below. So this is accessible on Android and on the internet. It works best on Google Chrome. Internet Explorer version 10 and above can also be used. And this is a model certificate. This is a certificate that is produced once an employee takes a test and clears it. It includes their date of taking the test and the percentage of marks obtained. For more inquiries, you can write to us at esh@ipleaders.in or visit the link above. You can also take down the number that is displayed on screen for a free consultation, or for any diagnosis into the compliance requirements with respect to your organization. Now I will quickly show what this toolbox looks like through a screencast, and I will then take you to the My CII link. So you have to give me a minute. So once you log in, basically when you log into the toolkit, this is what you will have access to. So this toolkit has two parts. One part is for the complaints committee, which includes all the guidance on how to decide cases, and it also includes some information on employee rights, because before deciding the case, a complaints committee also has to be aware of what the employees have learned in the sensitization, how they understand their rights, and what is their understanding of how to go about enforcing them. So that also, the complaints committee members should have reference to that. So this version that is for the complaints committee provides access to 6 modules. The first 3 are pertaining to employee rights, and these are the basics of sexual harassment, law definitions, ways to enforce rights, and those aspects. The next part, modules 4 and 5, are on how to effectively implement employers' duties. So a lot of duties are placed both on the complaints committee and the employer. So for example, the employer has to constitute ICCs in certain cities, in certain locations. Sorry, the employer has to display notices. Now these functions may be passed on, may be delegated by the employer during the enforcement stage, either to an ICC member or to someone from the HR. These are the likely ways. No employer typically will personally get into enforcement of this, implementation of this act. Of course, he will be available for inputs. So ICC members need to understand what the employer's duties are and how to go about helping with enforcement. Then The fifth module is on complaints committees, how they function, how should they decide cases, how should they take evidence. I'm displaying how to handle false complaints, because there's a risk. If there is a risk of abuse of a person's past, how can this be handled? There are videos as well under the toolkit. You will get access to a number of videos, and so I'm showing you how it briefly looks. Notes can be made on the right hand side pane. These will be saved. So these are questions that we have, some question answers. So that these are like situational assessments which can be used for self-study. So this is, for example, a typical video. It is just loading. I will not be playing the video here, but I'm just showing that a lot of videos are covered in this. The explanation is given through videos as well. The next aspect is the toolkit, which is in a way very handy for IPCs. So I'll just quickly take you through what the toolkit has. So the toolkit has draft anti-sexual harassment policies, a compliance checklist, notices. So these are available for viewing, and they can be downloaded. Annual report formats. So this is a notice format. Now this can also be downloaded on your computer through this download link. Okay. The composition of a capacity building program for ICC. Okay, we constantly keep upgrading this. We keep adding new formats, model presentations. In case the ICC refers someone to file an FIR, what kind of content should go in that FIR? That is explained here. If there's a settlement that is being suggested, what should the settlement agreement look like? So these are the aspects that have been explained. I will quickly show how to log in from. This is available on the MyCII link. So Mitali will be sharing the link and the details through an email later on, I believe. So members can log in. Mitali, which place is accessible?
Abudya, this is on the screen. If you just check on your left hand side, navigation, and go to CII services, it is the 5th button on your left hand side.
Online services.
Navigation, under navigation.
Sorry, yeah.
Navigation.
Harassment toolbox here.
Yes, that's the one.
CII services, you will be able to access it here. Once you can use your username and password and log in.
So yes, once you click on that toolbox, on that link, it will ask for your username and password. If you haven't registered yet, you can just, there's a small, very little form. So you can just enter your couple of details it will ask for. And then there'll be a separate username and a unique password which will be sent to your registered email ID. And through that you can access the toolbox anytime you want.
All right. So I'll just quickly say, if anyone wants to reach out to us, they can also ask Mitali, or any participants feel free to reach out to Mitali at CII, or the IDs that are mentioned on screen. ESH@ipleaders.in, and the website is given above. And the phone number for contacting is also given. So, one second. Is the screen visible, the PPT screen?
No, the PPT screen, we can't see that.
Okay. One second. It is. Yeah, so I'll just display the PPT. It is pausing it whenever I'm going back to the PPT. I think we'll have to send an email. Maybe. Mitali? Mitali?
Yes, I can hear you. Tell me.
Okay, it was pausing. It's pausing the application again and again. So you will have. We'll share the link and the details.
We'll share the link. Exactly. Okay. Exactly.
That brings us to the end of this. And Sibgoni, I'm extremely thankful to you for being present today and providing your inputs and for taking out taking out time for this.
Yeah.
It's
Thank
my
you.
pleasure. This topic is very relevant, very close to my heart, and I'm always happy to advise on this matter. I'm very keen to see the Sexual Harassment Act being implemented in the most easy manner, and I think IP leaders have done a great job with formulating a process which is easily accessible and also be able to support with advisory as and when required. You need to access training and access the correct manner in which to implement this act. It's important, and it's important not to really try to plug and play this act without the right advice. And of course, the fact that CII has encouraged us to also be able to discuss other manners in which to, like today. Excellent. Thank you. No, it was my pleasure.
Thank you. Thank you very much, Shibani. Thank you very much, Abudya, for sharing your knowledge on this very important act. In fact, I would like to thank all the participants as well who have taken out time to join us in this session, and in fact in the previous sessions as well. So I hope the sessions were very useful, and whatever questions you have, although people have asked a lot of questions in between the sessions, but please do send in your queries you can write into me, Mitali, mitali.ghosh@cii.in. You all have my email ID. So, or else you can write to Abudya as well on the ID which is shared during the presentation. So please send in your queries for any further questions or anything. And with that, we come to the end of the series. And I hope you've noticed that this toolbox which has been created by IP leaders, it's a very useful toolbox. Please visit the mycii.in website and log into the toolbox, make use of it, and it'll be, I'm sure it'll be beneficial for your organization. So in fact, in the last session, we have noticed that many of the members do not have the copy of the Act and its related rules. So what we have done, we have also put up the copy of the Act in a PDF format, which is downloadable on the toolbox, and the rules as well. So you can just visit the toolbox and download it for your use. So before I close the webinar, would like to share that all these recordings of the sessions today and previously done, we'll be uploading it on myCIN, and we'll be sharing the registration details as well, login details for that to all the participants. So thank you very much for your active participation. Thanks a lot, Abudya, and thanks a lot, Shibani, once again.
Thank you.
Thanks, Mitali.
Yeah.
Thank you.
Thanks. Bye-bye.
Bye.